Attorney Gens, would you like to give a comment on today's hearing?
Well, I'm pleased with the result. The motion for selective prosecution discovery has been largely allowed. It's been narrowed in a couple of respects which don't really affect what we're trying to do here. We've made a threshold showing that is very, very strong. We've shown that the city and the police department are maintaining a targeted list of certain types of protesters. Those are protesters against their rule of our policies and against vaccine mandates.
Please remember where they are and be respectful and proud. Thank you. You may have a seat. Good morning, everyone. Would the parties identify themselves for the record?
Media Revenue Commonwealth.
Attorney William Gens from the defendants.
And today this case is on for motion.
Yes, Your Honor. There were two motions that we served the last time with the understanding that we would address them today.
Okay.
One was the Commonwealth's motion regarding joinder, and the other was, and there's an opposition that has been filed, and the other was our motion, or at least not our initial motion on selective prosecution discovery.
All right. And I had an opportunity to read the supplemental that you also filed. I think it was last week or the week before.
I think it was last week sometime, and like the 29th of October, I believe. And of course, the court, we filed in court the original supplement.
Yes.
The original motion memorandum, and then we filed the supplement.
Yes. All right. So why don't we first address the issue regarding joinder?
Thank you, Your Honor. So the Commonwealth is asking you to join these two cases. We feel that the necessary prerequisites are satisfied here because they are related cases for the meaning of the joinder rule. In this instance, they are both pertaining to the same factual universe. The alleged offenses of disturbing the peace are alleged to have occurred on the same date, at the same time, essentially right next to one another, and involving the precise modus operandi, this precise same modus operandi for both defendants. In terms of that prejudice to the defendants, Commonwealth's position is that there wouldn't be any prejudice. Again, it's the same universe of facts, and any potential issues, I think, can be easily mitigated by proper jury instructions that suspect cases being joined, the jury find all the elements beyond a reasonable doubt for each individual defendant. So based on all that, we would, and for the sake of judicial economy, we would ask you to grant the joinder motion.
All right, thank you. Attorney James.
Your Honor, the defendants are not co-defendants under the understanding of that terminology. They're not engaged in a joint venture, alleged to be engaged in a joint venture. They're being both present at the same time. Incidentally, there were other individuals who were present as well. Using the Commonwealth's logic of things just being related in terms of time and place, if they were, say, riot at a football stadium, you could have one mass trial of everybody that was alleged to be rioting, people on different sides of the stadium. Having said that, there are other problems involved with the joinder of this matter of trial. I don't have a problem joining it for trial proceedings, but there are statements that are attributable, both verbal and nonverbal statements, to Ms. Llewellyn, which creates a proof problem, and a jury instruction, as the law makes clear, can't cure that type of interpretation by the jury, which is almost inevitable when people are being tried jointly with that one statement.
What specifically, what are the statements?
There was statements regarding a discussion about ceasing activity and responses from Ms. Llewellyn, also the nonverbal alleged statements. Was Ms. Llewellyn banging on pots and pans? None of which applies to Ms. Vitale, who's just there, standing there, which is a very good defense to a disturbed police charge. If he deserving of it. But the jury is invited in a co-defendant situation just by the nature of the joinder to impute the act of one to the other, the statements of one to the other. And that's the problem that we see here. It's a brutal issue.
Okay, I will look at it and I'll write a decision.
Okay.
All right, I'll take it under advisement. You both make good points.
Thank you.
All right, I'll look at it closely.
And would you like to address the other motions?
Please, why don't we move on to your challenge, selective prosecution.
A selective prosecution challenge is ultimately a very high order. And prosecutors' offices need to be able to exercise discretion. It's something that we invest them with as a matter of course and a good policy. However, the established law does create a mechanism, two-pronged mechanism to challenge the prosecutorial choices in given circumstances. The first part of that challenge is what we're involved with here, and for that, the threshold is actually quite low. The only thing that needs to be shown and we cite law to this effect, and there's more law out there that I didn't cite. The only thing that we really need to show is some degree of disparate treatment in the same circumstances. The materials that, and the second I want to say on that is, unlike other discriminatory type of challenges, we do not have to show that the defendants are members of a protected class based on race, etc. Content of speech qualifies political speech, and there's ample precedent on that as well. In this case here, I submit that our showing is quite robust. In fact, it probably exceeds most of the showings on the second prong in some respects. The first thing that we have, courtesy of some FOIA responses, is correspondence, email correspondence, there are two pieces, between the police, Boston Police Department, and the mayoral administration. The Boston Exhibit 2 is an email from the Boston Police. Sorry, one of our exhibits is an email from the Boston Police.
And you're
I'm talking about the very
is this in
first
the
memorandum.
supplemental?
Not the supplement, the very first.
This is the first,
It's actually exhibit 4 to the first memorandum.
okay.
And the pertinent part that I want to focus on is the third paragraph in the bottom last sentence. We have a master list of protesters. That's the Boston Police writing to the mayor's office in exhibit 4. And that's in April of 2022.
Say that again, please. That was exhibit 4.
That's exhibit 4.
Okay.
Then if we skip back to exhibit 2, we have, in June of 2022, the mayoral administration, representative from that, copying several other representatives of the mayoral administration, but directed to a Boston police captain with a list of persons. That list of persons has been aptly described in the media as BOP's enemies list, is a list of persons who, by and large, have subsequently been the subject of prosecutions, mostly for disturbing the peace or disorderly conduct, depending on how it was charged. I can tell you that I personally represent or have represented 6 of the people on this list, and as the body of our memorandum describes, they are prosecutions, including Ms. Vitale, Mr. Llewellyn, as well as Shannon Llewellyn, Michelle, are all still pending from their inception, and they're all at least, they range from about 10 to 18 months old at this point.
Is it for the similar activity that your 2 clients are alleged to have engaged in?
Yes, and so, and in protesting the same subject matter. In each and every case, they were protesting either mayor rule or vaccine mandates. There's another person on this list that I represent, Shannon Llewellyn. She has been prosecuted criminally, but she has been subjected to all sorts of administrative disciplinary proceedings within the Boston Police Department. There are other people who are prosecuted here, but I do not necessarily know the status of their cases or where their cases are. And we did a lot, or we didn't have time with the one on our own staff. Suffice it to say that these prosecutions more or less began in the spring of 2022 and really got underway after the June 2022 memorandum. Now, before I get into the selective prosecution data, I want to share with you what bookends this, because it's one thing to have an enemies list, but the motivation in of the attorney's office is made quite clear in a February 2022 joint statement that was published on Congresswoman Diana Presley's website, which co-sponsors, right in the materials that we took right off the website, by the Suffolk County District Attorney Pat Higgins. And
That's an exhibit?
It's the last exhibit in the first memorandum. It's exhibit 12, but it's at the very end. And I'm going to read just a few excerpts from the last page.
Your Honor, sorry to interrupt, and I don't know that this is necessarily relevant to the specific discussion process. I think that some of these we have no objection to. Others, I think, are objectionable for simple reasons such as the requested information doesn't exist or we don't know where.
I think we're talking about 2 different things. You're arguing selective prosecution independent of the discovery request, yeah?
It's intimately related to the discovery request. It's a discovery request by selective prosecution discovery, which is the first phase in the selective prosecution. You don't necessarily in the first part have to show intent and motive, but the point is, even at this stage, I can't.
Okay, so.
I think that we could perhaps be more efficient
Yes.
just by going through item by item. Some of these.
Have the 2 of you had an opportunity to sit down and actually go through everything
No.
item by item?
We have.
I've got no feedback from the prosecution on this. I will disclose to the court that in 2 other cases on that enemies list, the courts in the BMC have already made this motion. But I
Okay.
have not received any discovery yet. But
But you know I'm gonna make an independent decision.
I expect that you will. And that's why I'm taking great pains to try to clarify my position as much as I possibly can.
All right.
If I may, just for a moment,
Yeah, go ahead.
focus on the intent issue, because it's an element that should be considered. The statement says, make no mistake, the relentless and hateful attacks of Mayor Wu have no place in our society and are a far cry from the political debate and peaceful dissent that is welcome and necessary in a healthy democracy. We mostly explore what they consider to be peaceful dissent. How to get that. It is due to her brave, steadfast leadership, her commitment to science and the public health, including her common sense and life-saving vaccines.
Would you like some water, Mr. Kelly? We'll get you some.
That the city of Boston is making necessary progress. We stand in solidarity with her and call for an immediate end to this dangerous and hateful behavior. This is people holding signs, chanting slogans, maybe occasionally banging on pot cans. These are not people who are spray painting buildings, assaulting police officers. The heart soul of our area deals with that. We went back to the Boston Police Department website, which appears as exhibit
Thank you.
It's an exhibit in our materials that lists the arrests that the Boston Police effectuated.
Okay.
In
In the interest of time, it doesn't sound like the two of you have a conference.
No,
Or have attempted to determine what the Commonwealth is willing to provide. So I think it would behoove all of us, in the interest of time and efficiency, if the two of you conference, which is the purpose of a pre-trial hearing, and identify what the Commonwealth has no objection in providing. And then the disputed issues, then we can address. So, not to cut you off, but let me hear from the Commonwealth in terms of what they're willing to give you, and then what they're not willing to give you, and then we can hone in on that. Because you may be talking about things that they're amenable to.
well, let's see what their objections are.
All right, fair enough? Okay, go ahead.
thank you, Your Honor.
So just so we're all looking at the same document, what
Yes.
document are we referencing?
So I have defendant's motion for discovery requests regarding selective prosecution. And I understand that both defendants have filed this motion, and that the motion is substantively identical.
Okay, all right.
So with respect to item number 1, the master list of protesters referencing Boston Police email of April 4th, 2022.
What page are we on?
I'm on page 1 of the motion.
107, defendant's motion for discovery.
I have defendant's motion for discovery requests regarding selective prosecution.
Okay, fine. All right, I'm with you.
Thank you. Item 1, master list of
Attorney
protesters.
James, you with us too? We're all together?
Yes, we're on number 1 on that 2-page.
Okay. All right, go ahead.
No objection to that.
Okay,
Um,
I agree.
Then, for item 2, for each of the persons on the list, all evidence regarding prosecution by the Suffolk County District Attorney, including charges, docket number, police reports, case status, and disposition. So we would object to that on the basis that that would all be available to defense counsel on mass hooks. And then the police reports you would be able to obtain from the clerk's office.
Okay.
If I may just respond, Your Honor.
Yes,
The
go ahead.
problem with that is that the names that appear on the so-called enemies list are names, this is nicknames and pseudonyms. I'll give you some examples. This is going back to Exhibit 2 in the memorandum. This is a problem.
So let me ask you this, if they're nicknames and pseudonyms, then how is the Commonwealth supposed to accurately identify who's on the list?
Well, their agents have it as part of their materials and the list that they're creating, and so that presumably they know what it refers to. I've got here the Mendoza brothers. I don't know how many Mendoza brothers there are, which ones they're referring to or not referring to. A woman with the last name of Thorne, which, by the way, Shannon Llewellyn is listed here as Shannon K. Is Korea Lucine, which is not her real name. I happen to know that. The others are opaque to me to some degree. So I think that the Commonwealth needs to, at the very least, establish who they actually have on this list. Obviously, it was part of police procedure with their agents. And I can, of course, run those things down. That's how we got all the information we have gathered thus far as on mass courts, once we know of a particular incident or arrest.
But I think you've established that the list is not an accurate document in terms of individuals. And now you're asking the Commonwealth to establish its validity.
Well, my list, I'm not actually working off of that list. The one I have is that one that's the master list, which I haven't seen. But if the master list has anything like this on it, it's not necessarily going to enable me to do a mass court search.
What's the position of the Commonwealth?
So I think it depends upon the basis for which the defendants are seeking the information. So I disagree that the threshold showing relevancy has been made for a selective prosecution claim. If in seeking this master list, they're seeking evidence of specific bias or prejudice against these particular defendants that might be presented as impeachment evidence or evidence to impugn the credibility of the Commonwealth's evidence at trial, I think that falls more comfortably under 14A1A. So if that's the purpose for which they're seeking the information, I think more amenable to trying to work towards some way obtaining some of the information, but certainly the ability to do that is limited when we just have references to a master list and we have apparently a version of that that includes pseudonyms. I also am struggling to see particularly how having all of that information would necessarily show a bias against these specific defendants. It seems to me that if the theory is these specific people were targeted because of political ideology with which Boston Police or my office or the Blue administration disagrees, then the mere fact that their names are on this quote-unquote master list, I think is really evidence in and of itself and sufficient to make that point. Supplementing it with additional information about the other people on the list, their case dispositions, all that, I don't know that really adds much by way of probative value.
Okay.
If I may respond, Your Honor.
Well, let's go on to the third one. You may respond and then let's go on to the third one.
Okay, I'll respond quite briefly. I think that the district attorney misunderstands the intent or the purpose of this discovery. And I'm going to quote the Supreme Court of the United States in United States versus Armstrong here, 517 U.S. 456, 1996 case. A selective prosecution claim is not a defense on the merits of the criminal charge. itself, but an independent assertion that the prosecutor brought the charge for reasons forbidden by the Constitution. What we're attempting to show is two things at the same time. One is, here we have a class of people who are engaged in a specific content protest. Here's how they have been treated. Here are people engaged in protest with a politically favored content, and here's how they have been treated. In order for me to flesh out that list of people who are protesting disfavored content, I need to know who they are and how they've been handled. And I have a stumbling block here because I don't have a master list to see what's on it. The list I do have appears to be the supplement of the part of that master list has names that can't be searched. So it's an obstacle to attempting to engage in this investigation. So I think it's highly relevant to a selective prosecution. I agree with my brother that it's not necessarily relevant to trial issues or impeachment.
Okay.
I could just clarify, I don't think that I agree with defense counsel's representation or position as to the appropriate legal stance. I think we're dealing not with federal equal protection case law here, but we're in the realm of Articles 1 and 10, Commonwealth v. Laura, Commonwealth v. Long, Commonwealth v. Berthold B. Those are the controlling cases here. And there has to be a threshold showing of relevance in order to obtain this type of discovery. And it has to be relevant towards the standard that's articulated in Commonwealth v. Laura, which is first, that there's a broader class of people than those actually charged committed the offense. Second, that the disparate treatment was consistent or deliberate. And third, that there's a reasonable inference that the causal factor was some type of impermissible classification. I'm not understanding defense counsel's position as to who the broader class of people is who were treated differently. Commonwealth v. Long, I think, is a very instructive case at this point because it really hones in on the importance of comparing apples to apples with selective prosecution claims, especially in the discovery.
So why don't we do this? That particular item is hotly contested. I'll give both of you an opportunity to submit a written memo specifically on that issue. And let's move on.
Yeah, I don't.
Okay. So number two, the two of you will submit a written.
And incidentally, just to make things easy, Ron, I'm willing to waive number 4. I think it's duplicative of number 2.
Okay. So let's talk about 3.
For number 3, that's all the communications apart from emails referenced. To or from Boston Police, the Suffolk DA's office, and any member of the Mayor's administration regarding the treatment, arrest, or prosecution of criminal arresters. So a couple of stumbling blocks with this. I think one, I don't know that this necessarily exists. 2, if it does, I'm not quite sure how we would go about identifying those emails.
It seems rather broad.
And that's the third part. It seems overly broad to be burdensome. But I also think if you're just too close to the protected category of work product relative to legal decisions about charges and strategy.
Attorney Jens, it seems rather broad. You want to tailor it.
Sir,
Yeah, I think that we can. I recognize.
no, you need to put it away now, sir. Sir, put your phone away.
I'm doing it.
I recognize that the potential is there, given the way it's currently worded, to encroach on work product and type of privileges. And I certainly wouldn't be, I would certainly rely upon the Commonwealth's representation of something not being produced because it's actually work product. However, to the extent that it articulates a policy type of position. Either to or from those entities, the Suffolk County DA's office, the Boston Police, and the mayor's office. I think that it's highly relevant. This is especially the case where, in one of the cases that was attached as Exhibit A to our memo involving Sean Nelson. Sean Nelson is subject to a seizure and an arrest at the direction of Brianna Miller, who's one of the lieutenants in the Mayor Wu administration, who is directing police officers to effectuate this. We have, and then the DA's office relentlessly prosecutes.
Yeah, I'll note the objection number 3, I find is overly broad. If you want to resubmit something that's much more targeted, I'm always happy to consider. Number 3 is.
Okay, well, since we're going to brief number 2 anyway, I can tailor that and give you my reasons
That's fine.
as part of
And I'd be open
that
to
presentation.
that. But right now, the way it reads, it's too broad. Okay, that's 4 you have waived. Let's go on to 5. Identification of any operational unit of the Boston Police tasked with policing protest activity and the policies followed in determining which particular person would be prosecuted.
To the best of my knowledge, there is no such unit. I'm happy to ask.
Okay,
And that any policies or procedures would be available publicly online on BDE's website.
all right. So by agreement, number 5. Number 6, the statement of the practices followed in implementing each policy articulated in response to Form 5.
This seems to be the same as 5 to me.
Agreed. Attorney Jennings, do you agree with that?
I think that it's the same. I don't know if the Commonwealth really wants to produce that if it exists, but I'd like it.
But you agree it's the same?
More.
That 5 and 6 are talking about the same subject matter.
Well, 5 identifies any particular units of the Boston Police. 6 identifies a statement of practices followed, basically a policy one. So that's a lot easier to answer 5
Yeah,
and 6.
yeah. In 5, you're also saying, and the policies followed.
The policy followed might not necessarily be the same as the policy that's written.
Okay,
So if there are any written guidelines or statements, my understanding is that those are made available on BDE's website publicly.
all right. Okay, let's go on to 7.
So 7 is an explanation of how the decisions to investigate and prosecute in the present case were made and how they were compliant with policies and practices articulated in response to requests of 4 through 6. So I'll kind of break that up into pieces. An explanation of how the decisions to investigate and prosecute in the present case were made. That I feel is not a proper subject for discovery. I think that's certainly an argument and an issue and something that the Commonwealth can be pressed on at trial. But it isn't really a subject that you would produce in response to discovery requests. So I don't think that's a proper request in the discovery process.
And my concern would be, who would answer the question?
Whoever is
An
in
explanation?
charge of any such policy. Now, if there is no such policy, that's useful to me too. And the case law bears that out. I took these discovery requests, essentially gleaning them from the case law. And if there's no policy regarding how to handle particular case speech, then it can give rise to a conclusion, a judicial conclusion, because this is most certainly not a trial issue, that the policy is arbitrary and capricious, or that it is slanted and discriminatory one way or the other, or any other number of possibilities. So if the answer to that is it doesn't exist, I'm content with that answer.
I don't necessarily disagree with that, but I think that's an argument the Commonwealth will need to make either orally or in writing in response to some type of motion to dismiss or other legal argument like that sounds. I think it's It's asking for a legal position, not furnishing factual information.
Is it fair to say, Attorney Jens, that the court can expect a motion to dismiss filed on behalf of your two clients, arguing selective prosecution in the violation of their constitution?
Exactly right. And that's the next phase that I'm building towards.
Right, I get that. So I would suggest that number 7 is an argument that you present in that motion. I do not see that as something that the Commonwealth needs to answer at this point. And I'll know your judge.
Okay, then.
Okay? So the last request, any standards, policies, practices, or criteria employed by the district attorney's office to guard against the influence of political or other arbitrary or invidious factors in the selection of individual defendants for prosecution.
So I would say that we don't have any type of written policies. I mean, these are obligations that we all have as attorneys, just under the rules of professional ethics, under the Constitution, and we as employees are and members of the bar expected to follow them. So it's just an expectation that we will abide by our standard ethical and legal obligations. There are no written policies or procedures like this.
Okay, there's nothing independent of what is required under the case law and under the rules of professional responsibility. Is that correct?
That is my understanding, yes.
Okay.
I disagree. What my brother has just said, respectfully, is essentially the mantra of prosecutorial discretion. And what we presented here thus far, I haven't talked about it yet, is a compendium of how violent, felonious persons protesting on Boston Common tore Boston Common and downtown Crossing apart. And out of 52 prosecutions, 6 of them were dismissed outright. Only 2 convictions, conviction rate less than 4%. That is not coincidence. And the court, I think, after surveying all of our materials that we have already and will come in, will perceive that it's not coincidence that every climate change protester, every transgender protester, every so-called race-based protester, at least under this administration, 2 convictions, by the way, were accomplished under the predecessor administration. They're all dismissed.
Well,
all dismissed. And then people who are non-violent protesters.
They're dismissed, but in looking at the materials you submitted, many of them are dismissed upon the completion of community service as well, correct?
Some of them,
Finding ones in the
But-
State House, 28 hours of community service?
35 felonies amongst this here.
No, just answer my question. It's your materials that you submitted, right?
Yep.
Okay? The dismissed, but upon the completion of 28 hours of community service, yes?
Yes, and I'd liken
Fair
that,
enough?
I'd liken that to the fellow that pulled the fire alarm in the U.S. Congress to stop a vote, gets a $1,000 fine while other people go to prison for years.
All right.
This is a problem, not just here.
No, I understand. So number 9, the Commonwealth has answered accordingly, so that is the end of number, no, I'm sorry, not number 9, number 8. Okay, so going forward then, I would ask that you submit any materials or arguments that you want me to consider regarding request number 2. And number 3, you wanted to look at again, Attorney Jens?
Yeah, I will. I'll refine my position as best I can, because I do realize there are some considerations, valid considerations,
Okay,
in this, and I'll support it as best I can.
excellent. And then I'll also look at the request for joinder, and I'll make a decision on that. Is there anything else that either one of you would like to discuss at this point?
Not at this time, Your Honor, except for the next day.
Just regarding number 3, if defense counsel could provide, if possible, if not, I understand, but if possible, some type of time frame, maybe, that would be a bit easier on the Commonwealth in terms of ascertaining whether the requested discovery even exists.
We shall do that. I mean, I'm trying to focus on this particular administration, even though it appears to me that the policies that they pursue are legacy policies, the one that preceded. I will narrow it as best I can.
Okay. Thank you all for your patience and your courtesy. What is a good day for everyone to reconvene? You want to pick a 30-day date?
Would you prefer to be within 30, or would you prefer to go beyond this?
No, 30 days
You want
is
within
fine.
30? Okay. How is, I have December 18th, I have, the week after Christmas anyway. Wednesday's not good.
Whichever is date is most convenient for the court for that task.
I certainly would rather do it sooner rather than later.
Okay,
So why do we plan on early December?
I can do either. No, I can't do either. I can do December 8th.
Fine. What day of the week is
That's a
that?
Friday.
That's
I like Fridays.
Perfect. December 8th it is.
Thank you.
All right.
All parties present in third session, the matter is continued for further status for December 8th, 2023. Commonwealth's motion for joinder was taken under advisement.
Why don't we put it down?
December 8th for pre-trial.
And Your Honor, in terms of submitting briefs on the matter, when would you like those by?
At your convenience.
Okay.
But then Attorney Dennis, at your convenience, in
Yeah.
terms of the written materials.
Thank you. With regard to the docket entry, will it read, the discovery motion is allowed by agreement to the
I
extent?
did by agreement in part, denied in part, in items 2 and 3 to provide written memos.
Thank you so much.
December 8th for pre-trial. Thank you, everybody.
Thank you, Your Honor. Thank you, Your Honor.
Thank you.
Attorney Gens, would you like to give a comment on today's hearing?
Well, I'm pleased with the result. The motion for selective prosecution discovery has been largely allowed. It's been narrowed in a couple of respects which don't really affect what we're trying to do here. We've made a threshold showing that is very, very strong. We've shown that the city and the police department are maintaining a targeted list of certain types of protesters. Those are protesters against their rule of their policies and against vaccine mandates. Other protesters we've been able to show thus far, those who are protesting against perceived racism and against so-called climate change, and who are protesting transgender issues or who are themselves transgender. The city appears to be the DA's office appears to be batting 1,000 in terms of dismissing their cases and dismissing them promptly while they persist in prosecutions, full throttle prosecutions against individuals who are engaged in non-violent protests, charged with things like disorderly conduct, disturbing the peace, and the like. We've shown this overwhelmingly with regard to the George Floyd protesters, where out of 52 arrests, and 35 of those being felonious charges, 46 of them were dismissed or non-prossed. Only 2 convictions, which appear to be opportunistic looters, not protesters. Every single climate change protest that we've surveyed has been dismissed. Every transgender protester has been dismissed. This isn't coincidence. Anyone viewing this material would be well warranted in concluding that it's by design. It's no secret that this district attorney has made his partisan leanings quite clear in public statements. I'll read to you one of them that was read out in court, which was on the website of Diana Presley, co-sponsored by, amongst others, District Attorney Kevin Hayden, as well as a long list of other so-called political leaders. And it basically says, make no mistake, the relentless and hateful attacks on Mayor Michelle Llewellyn have no place in our society and are a far cry from the political debate and peaceful dissent that is welcomed and necessary in a healthy democracy. What's that peaceful dissent according to them? Look at the people that tore up downtown Boston and the downtown crossing in the George Floyd riots. Look at the people who are protesting climate change by exposing their rear ends at the State House just a couple of months ago in June. Look at the transgender protesters who attacked people who were themselves protesting a drag queen story hour on video, on film, no doubt about it. They are attacking them, they're not prosecuted, and one of the people they attacked gets prosecuted defending himself. He got a not guilty out of this very court. Further statements within that statement regarding Mayor Wu, it's due to her brave and steadfast leadership, her commitment to science and the public health, including her common sense and life-saving vaccine mandates, that the city of Boston is making no necessary progress. We stand in solidarity with her and call for an immediate end to this dangerous and hateful behavior. This district attorney has taken a public position that characterizes legitimate, peaceful protest as being hateful and intolerable in our society, while at the same time excusing felonious conduct on behalf of other protesters who are promoting agendas that he agrees with. It's divisive, it chills the First Amendment, and it contributes to what social scientists call delegitimization, which is the lack of confidence of the public in their institutions, including the judiciary.
Right.
Our case is about addressing that right now. It's no longer about the protest itself.
Thank you. That was great. Anyone else want to make a comment? Catherine, you're welcome. Or
Not today.
Shannon,
Thank
you don't want to? Well, we wish you a lot of luck.
Thank you. Thanks for
And
being here.
Commonwealth Registry covered it. Thank you.
Bill.
My pleasure.
Okay.
How are you feeling?